Rule 6, rules relating to pleadings, continued. For damages for personal injury, the plaintiff's date of birth, nature and extent of the injuries, effects and duration of the disability alleged to give rise to such damages, and shall state separately what amount, if any, is claimed for. Pain and suffering, temporary or permanent, and which injuries have caused it. Disability in respect of any of income, earnings lost to date and future loss, enjoyment of amenities of life, disfigurement, description thereof, and stating whether it is temporary or permanent. As we also continue with the rules relating to pleadings regarding damages resulting from death of another, date of birth of the deceased, that of a person claiming damages as a result of the death. Relying on an agreement governed by legislation, state and nature and extent of compliance with provisions. Plaintiff sues cessionary, name, address, and description of the cedent at the date of the cession, as well as the date of the cession. Suing on a contract, if suing on a contract, whether the contract is in writing or oral, when and where and by whom it was concluded. If the contract is in writing, a copy thereof, or the part relied on in the pleading, shall be annexed to the pleading. The pleading shall be deemed an irregular step, and opposite party shall be entitled to act in accordance with Rule 60A. Rule 7, amendments of summons. A summons before being issued by the registrar or the clerk may be changed at any time. Any alteration or amendment on a summons has been issued by the clerk of the court, but before service shall be initialed by the legal representative or plaintiff, and shall be initialed and the date stamped by the registrar or the clerk of the court before service by sheriff. Failure to follow this process will mean that the amendment has no effect. Provisions of Rule 55A shall apply to the amendment of summons after service. Let's look at examples of some causes of action. Contractual claim. A party wishing to claim a specific performance in terms of a contract must prove the existence of a contract, allege and prove the material terms of the contract, allege and prove that he has complied with his antecedent or reciprocal obligation, allege non-performance by the defendant of his obligation, the nature of the relief sought, and a party wishing to claim damages due to a breach of contract must allege and prove the contract's existence, allege and prove the material terms of the contract, its breach, that the other party was immoral and has repudiated the contract, that he has suffered damages, that the damages flow naturally and generally from the kind of breach of the contract in question, or if not, that in the special circumstances of the case existing at the conclusion of the contract, that damages were within the contemplation of the parties when the contract was concluded. A causal link between the breach and the damages, as well as claiming for costs. Intellectual claims. The actual legis aculia enables the plaintiff to recover patrimonial loss suffered through a wrongful and negligent act of the defendant. The scope has been widened to enable the plaintiff to recover a purely economic loss. Its principles also apply to a claim for damages suffered as a result of bodily injuries or death of another, e.g., a breadwinner. The plaintiff must allege and prove the act or omission which is the basis of his cause of action, negligent, and the particular grounds of negligence must be detailed. The causal connection between the negligent act relied upon and the damages suffered, claim for damages, and as well as claim for costs. Claim on a dishonored check against the drawer. A plaintiff claiming on a dishonest check must allege and prove that he is the legal holder of the check thereof, that the document is a check, that the check was drawn by the defendant, and that the check was duly presented for payment in terms of Section P54 of the Bills of Exchange Act, that the check was dishonored in terms of Section 45, that notice of dishonor was given in terms of Section 46, or that notice of dishonor was dispensed with as set out in Section 48, and claim for costs. Claim against a surety. A plaintiff who wishes to claim on a deed of suretyship must comply with the ordinary rules relating to the pleading of contracts. The onus rests on the plaintiff to allege and prove the following: a valid contract of suretyship, the existence of a claimable and payable main debt, that the cause of debity is one in respect of which the defendant undertook liability, the indebtedness of the principal debtor. Claim for commission by an estate agent. An estate agent who wishes to claim commission must allege and prove the following: compliance with provision of Section 26 of the Estate Agent Act, compliance with provisions of, I'm just repeating that, is 26 of the Estate Agents Act, compliance with the requirements of the Fidelity Insurance, a mandate to find a purchaser or a seller, due performance of his or her mandate, the commission payable. A claim for repayment of a loan, taking into regard whether such a loan falls within the ambit of the National Credit Act. In a claim based upon a loan, the plaintiff must allege and prove the contract of loan, the money was advanced in terms of the loan is repayable and claimable, claim for costs and interest. Claims for interest. The rate at which interest, if claimed, is calculated must be set out in the particulars of claim. Interest may be claimed where there's an agreement to that effect between the parties, where the defendant is in mora. The case of Trust Bank versus Van der Waals, it's a 1972 case, extension of such an agreement must be alleged in the particulars of claim, as well as the rate agreed upon by the parties. In the case of Koyeya versus Watras, the 1923 case, it was held that the summons should allege an agreement to pay interest, but where it was not alleged, although claimed, the defect in summons was cured by evidence from the plaintiff to that effect, evidence that was not objected to by the defendant, and the defendant, in fact, led reparting evidence. If interest was agreed upon, but a rate not specified, and if it is not fixed by trade usage or another law, which should be alleged in the particulars of claim, the rate which applies is the one which is determined in terms of Section 1, subsection 2, the prescribed rate of interest Act. Service of process notices and other documents. A summons is served in terms of Law 9 by the sheriff. A cornerstone of our legal system is that a person is entitled to notice of the institution of proceedings against him or her. The legal proceedings in general commence unless the party against whom the relief is claimed is notified the initiating process by means of service. When proceedings have begun without a notice, the subsequent proceedings are therefore null and void and may be disregarded or set aside at the option of the other party. However, if the initiating document, such as the summons, was served correctly, the subsequent proceedings are not void but may be voided. The summons may be set aside as an irregular step, although the court may condone the irregularity. All process shall, subject to the provisions of this rule, be served upon person affected by the delivery of a copy thereof in one or other of the following manners: to the said person personally or her duly authorized agent, provided that with such person is a minor under legal disability, service shall be effected upon the guardian, tutor, curator, or the like such manner or a person under disability. At the residence or place of business of the said person, guardian, tutor, curator, or the like to some person apparently not less than 16 years of age, apparently residing or employed there, provided that the purpose of this paragraph when a building other than an hotel, boarding house, hostel, or similar residential building is occupied by more than one person or family. Residence or place of business means that portion of the building occupied by the person upon whom the service is to be effected. At the place of employment of the said person, guardian, tutor, curator, or the like, or to some person apparently not less than 16 years of age, and apparently in authority over him or her, in the absence of such person in authority, to a person apparently not less than 16 years of age, and apparently in charge at his or her place of employment. If the person to be served has chosen a domicilium sistandi by delivering or leaving a copy, therefore, at the domicilium chosen. In the case of a corporation of a company by delivering a copy to a responsible employee thereof as it is, or its registered office, its principal place of business within the course jurisdiction, or if there's no such employee willing to accept the service by affixing a copy to the main door of such office or place of business in any manner provided by law. If the plaintiff or his or authorized agent has given instructions in writing to the sheriff to serve by register's post, the process shall be so served. Rule 9, subsection 3 provides more information. A debt counselor who makes a referral to court in terms of section 86(7) or 86(8) the National Credit Act may cause the referral to be served by registered post or by hand. In the case of a minister, deputy minister, provincial premier, in his or official capacity, the state or provincial administration, at the office of the state attorney in Pretoria, or branch of that office anywhere within the country, which serves the area of jurisdiction of the court from which the process has been issued, to any agent or legal practitioner who is duly authorized in writing to accept service on behalf of the person upon whom the service is affected in any applicable manner prescribed in this rule. Where a local authority or statutory body is to be served on the town clerk or assistant town clerk or mayor of such local authority, the secretary or similar officer or member of the board or committee, such body, in any manner provided by the law. Where a person is to be served with any document initiating application proceedings is already represented by a legal practitioner of record, such document may be served upon such legal practitioner by the party initiating proceedings. Let's look at defendant action. A period in which the defendant must enter an appearance to defend is 10 days after the service of summons on the defendant, provided that the days between 16 December and 15 January, both inclusive, shall not be counted. Let's look at Rule 62, security for costs. The party entitled and desiring to demand security for costs from another shall soon as practicable after commencement of proceedings deliver a notice setting forth the grounds upon which security is claimed and the amount demanded. If only the amount of security demanded under sub-rule 1 is contested, The registrar or the clerk of the court shall determine the amount to be given, and his or her decision shall be final. Rule 62 provides its own remedy for failure to furnish security, and therefore Rule 60 is not applicable in this case. Rule 62, subsection 4 stipulates that if security is not given within a reasonable time, the court may dismiss the proceedings, instituted or strike out any pleadings filed by the party in default. Actions by a peregrini or a peregrinus, who is the plaintiff who does not own a mortgaged immovable property in the Republic, may be ordered to give security for cost of his action. The court has a discretion whether or not to order security to be lodged in any given case, or the relevant facts, as well as equity and fairness to both parties, will be considered. In the case of Exploitiate versus Honeck, it was held that the fact that the applicant for cost for security would have to be proceeded abroad against the peregrinus respondent if he obtained a cost order in his favor, with the associated uncertainty and inconvenience that would entail, and that it would be substantially more expensive to do so than litigating within the Republic, was one of the fundamental reasons why the peregrinus should provide security. Rule 15, declaration. If a defendant who has been served a simple summons defends the action, then the plaintiff is required to deliver a declaration. To deliver a declaration within the time stated does not entail an automatic bar. And notice in terms of Rule 21B, subsection 2, notice of bar must first be given only if the plaintiff is in default of the notice of bar. Is he or she automatically barred from delivering a declaration as envisaged in terms of Rule 21B, subsection 3, and the defendant may apply to have the plaintiff's claim dismissed with costs. Rule 19, exceptions and applications to strike out. An exception is a legal objection to the opponent's pleading. It complains of a defect inherent in the pleading. An exception provides a useful mechanism for weeding out cases without legal merit. The grounds of an exception to summons are twofold. The summons does not disclose the cause of action, but the summons is vague and embarrassing. There are two possible grounds to a plea. The plea does not disclose the plaintiff's claim, or the plea is vague and embarrassing. In terms of Rule 19, who intends to take an exception shall do so by notice within 10 days of receipt of the pleading. The party is given 15 days to remove the cause of the complaint, failing which the excipient may set the matter down hearing in 10 days. Failure to set down within 10 days will result in the exception lapsing. Rule 17, the plea. The plea is essentially the defendant's reply to the plaintiff's particulars of claim and contains the defendant's defense to the plaintiff's claim. There are two main kinds of pleas. Where a defendant has delivered a notice of intention to defend, the defendant shall, within 20 days after service upon him or her, the declaration, or within 20 days after delivery of such notice of intention to defend, in respect of a combined summons, deliver a plea with or without a claim in reconvention, or an exception, or without application to strike out. The plea must be dated, signed by the defendant or his or a legal practitioner, and the defendant's address must appear on the plea. Admission of facts. An admission puts no point in issue at all, but operates to eliminate the admitted fact from the issues to be trialed. Denial. A denial places allegation of fact in the opponent's pleading issue and must be proved at trial. A bare denial is not admissible. Should the defendant's plea be such a denial, This plea is regarded as an irregular step, and the provisions of Rule 60A can be invoked by the plaintiff. Confess and avoidance. In this form of pleading, the defendant admits the facts alleged by the plaintiff, but alleges certain other facts which would have the effect of putting a different complexion on the facts given by the plaintiff, or the legal conclusion of the plaintiff seeks to draw from the facts pleaded. A special plea. A special plea is a plea which raises a special defense and is directed at an underlying legal problem in the plaintiff's case rather than at the merits of the case. A special plea is procedural in character, which either destroys or postpones the operation of the cause of action. A special plea may be categorized into pleas in bar, dilatory pleas, the effect of delaying or suspending the action, and plea in abatement. And plea in abatement has the effect that the action is extinguished. A dilatory plea jurisdiction, the onus is on the plaintiff to show that the court which is sued has jurisdiction, lis pendis, arbitration as a condition precedent to the right to sue. Special pleas in abatement, prescription, and limitation of actions, res judicata. Rule 14, application for summary judgment. After a defendant has served a plea on the plaintiff may, under certain circumstances, apply for summary judgment. The amendment to the time when a plaintiff may apply for summary judgment is complete change from the previous Rule 14. The cause of action of which application may be brought are for the following claims: on a liquid document, for a liquidated amount of money, for delivery of a specified movable property, or ejectment. The application for summary judgment must be delivered within 15 days of service on the plaintiff of the plea. Such notice shall comprise a notice of motion together with a founding affidavit made by the plaintiff or anyone who can swear positively to the facts. Contents of the plaintiff's affidavit in terms of Rule 14. Plaintiff's affidavit must now contain the following: a verification of the cause of action and the amount claimed, identification of any point of law upon which the plaintiff relies, a statement of facts upon which the plaintiff's claim is based, and a brief explanation why the defense, as pleaded, does not raise an issue for trial. In terms of Rule 14, the plaintiff must also attach a copy of the liquid document if claim is based on such a document. We continue with also explaining summary judgment. What can the defendant do when a summary judgment application is delivered in terms of Rule 14? The defendant may give security to the plaintiff for the satisfaction of the court for any judgment, including cost, which may be given, satisfied to the court, an affidavit that the defendant has a bona fide defense, and in such an affidavit disclose fully the nature and grounds for such defense. The plaintiff bears the onus of proof in the case of Edwards versus Amendus. The court held that only where the court had no reasonable doubt the plaintiff was entitled to summary judgment, the plaintiff had an answerable cause, would summary judgment be granted. Findings of the court at the end of the application for summary judgment, the court may make the following findings. In terms of Rule 14, the defendant is entitled to defend the entire claim. The defendant is entitled to defend part of the claim. If the court does not find that the defendant is entitled to defend the claim in full or in part, the court will grant summary judgment, as well as judgment on the main claim or the part of the claim of the plaintiff. Rule 14, Section 7 states that if security, as mentioned above, is given, the court shall give leave to the defendant to defend the matter and will proceed as if no application for summary judgment has been made. Rule 18, an offer to settle. In any action in which a sum of money is claimed, either alone or with any other relief, the offer must be made any time before judgment, unconditionally, without prejudice. It should be in writing. This offer to settle the plaintiff's claim shall be signed either by a defendant himself or herself, or by his or her legal practitioner. The latter has been authorized thereto in writing. Notice of any offer or tender in terms of this rule shall be given to all parties to the action and shall state if it is conditional or without prejudice as an offer of settlement. If there is an offer to pay all or only part of the cost, if the offer or tender is made by way of settlement, both of claim and costs, if the defendant disclaims liability for the payment of costs for the part thereof, the action may be set down for the question of costs alone. A plaintiff may, within 15 days after the receipt of notice or thereafter, with consent in writing of the defendant or third party, by an order of court, accept any offer or tender. Rule 18 has the following disadvantages. The plaintiff may not know how the amount is calculated, and if he or she is at a disadvantage in preparing for trial. If the plaintiff proves more than the offer in terms of Rule 18, he is entitled to the awarded or to be awarded his full costs of the action from the defendant. If the plaintiff proves an amount equal or less than the offer in terms of Rule 18, the defendant pays the plaintiff's costs to the date of the offer, and the plaintiff pays the defendant's costs from the date of the offer to date of judgment. The defendant may include costs in the amount paid in as offer of settlement. So in this case, I would advise everyone to actually take time to look at an offer to settle and weigh their options carefully now, because now the plaintiff now runs a risk of having to pay costs if they are not able to get, if they actually get the equal amount to the offer or less than the offer. Rule 18A, interim payments. An interim payment can only be made in actions for damages for personal injuries or the death of a person. The plaintiff may apply to the court for an order requiring the defendant to make an interim payment in respect of a claim for past medical costs and past loss of income arising from physical disability or the death of a person. At the hearing of the application for an interim payment, the court has to be satisfied that the defendant has admitted liability in writing or for the plaintiff's damages, or the plaintiff has obtained judgment against the respondent or damages to be determined. Once the court has granted such interim payment, the plaintiff can only withdraw his or her action with the leave of the court. Rule 20, claims and reconvention. It often happens that a defendant not only defends the action brought against him by the plaintiff, but also has an action of his own to bring against the plaintiff. It is desirable that the defendant should be allowed to link his action with the plaintiff's, so that in a proper case that the two actions may be heard together, and so that the judgment in the two may be pronounced at the same time. The counterclaim can be set out either in a separate document, in a portion of the document containing the plea, but headed claim in the convention. A counterclaim must be filed at the same time as the plea. The rules and principles applicable to the summons and the particulars of claim also apply to the counterclaim. There are, however, procedural differences between the summons and the counterclaim. The plaintiff not to file an entry of appearance to defend, the defendant can only apply for summary judgment in terms of Rule 14, and see also Rule 33 for cost disadvantages to a successful defendant. Section 21, replication and plea in reconvention. The replication is the plaintiff's answer to the defendant's plea. It is unnecessary to deliver replication if the plaintiff wishes only to deny the allegations contained in the plea, since if no reply is filed within the prescribed time limit, the plaintiff is deemed to have denied the allegations in the plea. The replication need to be filed only if the plaintiff wishes to plead on fresh facts in answer to the defendant's plea. The replication is the proper place for meeting the plea by confession, avoidance, and avoidance. The plaintiff is, however, restricted to answering the allegations made by the defendant in his plea. He may not, in his replication, introduce the phrase cause of action. Rule 21, the clause of pleadings. The clause of pleadings is called legisca contestatio, is a concept that is used to indicate from a given moment that the parties are no longer entitled to exchange pleadings. This means that both parties have enough time to define their cases by way of pleadings, and pleadings are considered closed if any of the parties joined issue without alleging any new matter, without adding any further pleadings. The last day allowed for filing of the replication or subsequent pleading has lapsed, and it has not been filed. The parties agree in writing, the pleadings are closed, and such agreement is filed with the register of the clerk of the court. The parties are unable to agree is the close of pleadings and the court upon which an application of a party declares them closed. Rule 21A, failure to deliver pleadings. Barring in terms of this rule is as follows. Failure to deliver a declaration of a plea or a plea within the time stated does not entail an automatic bar. A notice of bar must be given. Failure to deliver a replication or subsequent pleading within the time stated entails an automatic bar, and no notice of bar is necessary. For the purpose of this rule, the days between 15 December and 15 January, both inclusive, shall not be counted in the time allowed for the delivery of any pleading. Rule 55A, amendment of pleadings. Any party desiring to amend pleading or document other than an affidavit filed in connection with any proceedings shall notify all other parties of its intention to amend and shall furnish the particulars of their amendment. Such notice referred states that unless a written objection to the proposed amendment is delivered within 10 days of delivery of the notice of amendment, the amendment will be effected. An objection to a proposed amendment shall clearly and concisely state the ground upon which the objection is founded. If an objection is delivered within the period, the party wishing to amend within 10 days lodge an application for leave to amend. If an objection is delivered, the proposed amendment shall be deemed to have been consented to. Party who gave notice of the proposed amendment may, within 10 days after expiration of the period, effect the amendment, unless the court otherwise directs. An amendment authorized by an order of the court may not be affected later than 10 days after such authorization, unless the court otherwise directs. Any party who is entitled to amend shall effect the amendment by delivering each relevant page in its amendment form in terms of Rule 55A. An application for amendment in terms of Sub-Rule 4 is an application of notice in terms of Rule 55 is made. A court hearing an application for amendment as the restriction, as at the discretion whether or not to grant it. Section 111 or Section 111, an amendment of proceedings. In any civil proceedings, the court may, at any time before judgment, amend any summons or other document, part of the record, provided that no amendment shall be made by which any party other than the person applying for such amendment, notwithstanding a judgment, be prejudiced in the conduct of his action or defense. The general approach to be adopted in applications for amendment has been set out in numerous cases. The vital consideration is that amendment would not be allowed in circumstances which will cause the other party such prejudice as cannot be cured by any order for costs or appropriate postponement. In the case of Moolman versus Estate Moolman, the following statement was made by Judge Walter Mayer that it has frequently been relied upon. The practical rule adopted seems to be that the amendments will always be allowed unless the application to amend is mala fide, or unless such amendment will cause an injustice to the other side, which cannot be compensated by cost. In other words, unless the parties cannot put back for the purposes of justice in the same position as they were when the pleadings which it is sought to amend were filed. Rule 22, set down for trial. After the pleadings have been closed, the plaintiff will deliver a notice of trial a day or days approved by the registrar or clerk of the court. So actually the clerk or the registrar of the court is the one that gives you the trial date when you set down the matter. If the plaintiff does not deliver a notice of trial within 15 days after the pleadings have closed, the defendant may do so. Delivery of such notice shall be at least 20 days before the trial date. The date for the hearing of an action will only be allocated by the court once the matter is trial ready. Rule 16, request for further particulars.